My name is Jeremiah Williams. Today we will be discussing some key takeaways from EntertainmentLawUpdate.com's podcasts, episode number 70. One of the first things that I noticed in this podcast is that a good attorney is expensive. In the case that was mentioned, the Marvin Gaye estate actually was pursuing a charge against another person for use of one of Marvin Gaye's songs, and they said that they had done it illegally. The Marvin Gaye estate actually won their court case, but the court fees did not cover the cost of the legal fees, so they filed another suit to cover those fees. The amount that they were seeking was upwards of $5 million to cover every fee. They actually factored out all the amount of hours roughly on the show, and it came to approximately $560 an hour for all the, of course, you've got the lawyers, you may have under lawyers doing some things, and people doing research and filing documents, and so obviously it's more than just one lawyer, but that team in general made approximately $560 an hour on this case. The key takeaway from that is always get rights to what you use. It's by far better to pay for the copyright, to pay the usage, than it is to have to go through a lawsuit, pay your own lawyer fees. If you lose, pay someone else's lawyer fees potentially. The second thing I noticed is that the industry is changing. Years ago, things were a lot stricter. People could get away with a lot less. The digital age has changed things so much, and what might have been deemed infringement 10 years ago might actually fall under the fair use now. The people who currently own the rights to most or all of the Abbott and Costello shows sued a company for a play in which a boy and his puppet reenacted the entire Who's on First routine. What came out of this was that we find that the courts are actually placing more weight on one factor than on others in the case. There were actually 3 to 4 main aspects. The court sided with the Abbott and Costello Foundation on the first 2, but the deciding factor was actually the third factor, in which they sided with the defendants. This came up because of 2 things that they said. The reason that they sided with them, first was the transformative nature weighed heavier than the original 2 things, despite the fact that it was an exact reenactment, despite the fact that it was done as a play, very similar to what the original performance was. They said the transformative nature is more important because the first one was done strictly for comedy. The other actually had an alternative meaning and use inside the whole context of the play. The second thing that they said is that fair use may actually have saved them on this. The market comparisons that they did showed that the second play, the play, did not affect the market of the original Abbott and Costello fans. They said if anything, it actually expanded the potential viewing because people who would see that would go and look up the original and come back and become even more fans. So the government did side with the defendant on this case. Key takeaway on that, if at all possible, avoid fair use. This also goes back to getting permission for everything we use, because in the end, it's just safer and better to get permission for everything. Finally, are there actually double standards in the current system? The case that was talked about was the filing for a trademark by the Asian American band The Slants. They were compared actually to the current suit for the Washington Redskins, and what they came and said is, we find that the Slants were actually given theirs after a couple different trials, and the Redskins were not. And the podcast actually went into saying, well, maybe it's because it was Asians sort of slamming other Asians, while the Redskins is white Americans slamming Native Americans. So the key takeaway on this for me was stay away from anything that is obviously offensive. Obviously, anyone can offend anyone, but we should still seek to find the least offensive options.